The Subcommittee on Elections of the Committee on House Administration will now come to order. I'm delighted that we have several of our members with us today. I realize that we are mostly in our districts this week, but thank you to the members for logging on and being a part of this very, very important hearing. We have Mr. Aguilar, Mr. Steele, Ms. Ledger-Fernandez, Mr. Davis, Ms. Scanlon. If she's not on now, she is soon to arrive, and of course, the chairman. So thank each of you for joining us today. We do have a quorum. As we begin, I want to note we are holding this hearing in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. Generally, we ask subcommittee members and witnesses to keep their microphones muted when not speaking to limit background noise. Members will need to unmute themselves when seeking recognition or when recognized for their 5 minutes. Witnesses, and thank you for joining us today, the witnesses will also need to unmute themselves when recognized for their 5 minutes or when answering a question. Members and witnesses, please keep your cameras on at all times, even if you need to briefly step away. Please do not leave the meeting or turn your camera off. That would not be a good idea. I would also like to remind members that the regulations governing remote proceedings require that we cannot participate in more than one committee proceeding at the same time. At this time, I will ask unanimous consent that the chair be authorized to declare a recess of the subcommittee at any point, and that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record. I don't hear any objections. Thank you to my colleagues for that. Hearing no objections, it is so ordered. Ladies and gentlemen, today's hearing is the third in a series of hearings this subcommittee is conducting this year, examining voting and election administration in America. Today, we will examine 3 types of state and local election administration laws: those requiring voters to present identification to vote, those requiring voters to provide documentary proof of citizenship in order to register to vote, and those governing the provision of multilingual voting support. Since the Supreme Court back in 2013, in the case of Shelby County versus Holder, a number of states have adopted very strict voter ID laws requiring voters to present a qualifying voter ID in order to vote, some doing so immediately after the court's decision. Voter ID laws have been shown to disproportionately burden minority voters. That is a demonstrated fact. I don't believe there are many experts who would dispute that. Voter ID laws have been shown to disproportionately burden minority voters. African American and Latino and Native American voters, for example, are less likely to have qualifying forms of ID. They are particularly burdened by the cost of obtaining IDs. And studies have shown that strict voter ID laws disproportionately decrease minority turnout. We should all be concerned about that. Voter ID laws adopted in Texas and my state of North Carolina imposed particularly troubling burdens on minority voters. Now, before the Shelby decision, both Texas and North Carolina had to obtain pre-clearance of their voter ID laws from the Department of Justice. Within days of that decision back in 2013, these states imposed restrictive voter ID laws, laws that their legislatures knew would not have survived the Department of Justice's review. Federal courts found that the laws were enacted with the intent, not just the effect, but the intent to discriminate against minority voters. The courts relied on evidence that the legislatures knew the laws would disproportionately burden minority voters and provided pretextual justifications for enacting them. In my state of North Carolina, a federal court found that our voter ID law, in particular, targeted African American voters with almost surgical precision. And I put that in quotes, almost surgical precision. That was a federal court. The Texas and North Carolina voter ID laws illustrate the critical role the Voting Rights Act played in protecting the rights of minority voters and exemplify the need for Congress, for us, to enact new legislation to revitalize federal protection of minority voting rights. Like voter ID laws, laws requiring voters to provide documentary proof of citizenship to register to vote have been shown to disproportionately burden minority voters. Studies, qualitative studies, have shown that obtaining the required documentation can sometimes cost in excess of $1,000, leading some to characterize these laws as imposing a modern-day poll tax. These documentary proof of citizenship laws have been shown to disenfranchise tens of thousands of voters and are justified by little more than unsupported claims of voter fraud. Lack of access to multilingual voting support also poses a significant burden on minority voters. Studies, credible studies, have shown that language minority voters are more likely to be registered and turn out at a higher rate when they have access to voting information in their native language. And I hope we will get into that today. Despite this evidence, states and localities continue to deprive voters of multilingual voting support. The testimony provided today will help this committee as it seeks to understand what needs to be done to ensure that voter ID laws, proof of citizenship laws, and laws and processes governing the provision of multilingual voting materials are non-discriminatory. We must do that. We should be making it easier for all citizens to vote, not leaving state and local governments with unchecked authority to enact legislation that imposes discriminatory barriers to the ballot. And so I know this was a little long, but I look forward to hearing from today's witnesses and working with my colleagues on both sides of the aisle on these important issues. Thank you for listening. I will now recognize the ranking member, Mr. Steele, and thank you to the ranking member for visiting me in my office the other day. We had a very delightful and productive conversation, and this will continue to happen throughout our work. So thank you, Mr. Steele, for visiting with me, and now I'll recognize you for an opening statement.
Thank you very much, Mr. Chairman. It's good to see you today. It was a great conversation in your office last week. I appreciate you holding today's hearing on this important topic. I think it's absolutely critical we find ways to work to ensure our elections are free, fair, and secure. And photo ID is a simple, common sense way that we can assure that every legal vote is counted and only legal votes are counted. 36 states currently require some form of voter ID to vote. In 2020, we saw more people cast their vote than in any presidential election in history. In fact, voter turnout increased in every state, including some of the sharpest increases occurring in states that required voter ID. And further dispelling the myth that voter ID laws deter voting, voter turnout increased among all race groups in 2020. And contrary to some of the written testimony put forward, in the real world, I think it's clear that voter ID does not deter people from legally voting. The data just doesn't support it. Common sense doesn't support it. And I think the American people know that. Among the states that asked for ID to vote is my home state of Wisconsin, as well as the home state of the President of the United States, Delaware. Other states include Connecticut, Rhode Island, New Hampshire, and the list goes on. And for the purpose of this hearing, I'll reiterate what I've said at previous hearings. Republicans want to ensure that every eligible person who wants to vote is able to cast a vote. And that we make sure that every lawful ballot is counted according to state law. We want to make sure that it's easy to vote and hard to cheat. The far left has been working overtime to mischaracterize new voting laws across the United States. The left's characterization of voter laws, like those recently passed in Georgia and other states, earned multiple Pinocchios and pants on fires when they were raided. by fact checkers. Unfortunately, Democrats' election legislation, H.R. 1 or S1 in the Senate, it guts voter ID laws. And they continue to push this false narrative that election safeguards like voter ID are somehow racist or an attempt by Republicans to suppress the votes of Americans from minority communities. Americans are used to showing their ID to do common things like open a bank account, buy alcohol, fly on a plane. I don't believe my local bank or the Quick Trip convenience store or the TSA is racist or has discriminatory intent when they ask for my ID. I think it's common practice. But even if a voter doesn't have an ID on election day, states have a process to allow the voter to cast their vote by filling out a provisional ballot. This ensures their vote, if proven lawful, is counted and that the voter is not denied their constitutional right to vote. For example, Texas has, whose voting practices are often, I think, unfairly characterized, accept a voter's utility bill, bank statement, government check, birth certificate, or a paycheck. Delaware also has a process for this. These options make sure that access to the polls for all Americans to legally participate in the process. Equally as important as ensuring voters have access to the polls is ensuring people have confidence in our election results, and voter ID laws can help with this. Most Americans would agree that it's important that only U.S. citizens are voting in our elections. We recently saw in Illinois issues where hundreds of non-citizens were accidentally registered to vote through the state's automatic voter registration program. This is a problem for the obvious reason that we don't want illegal votes cast in our elections. But it's also a problem because if an ineligible individual voted because flawed automatic voter registration made them think that they'd face serious consequences if caught, all because of the state's error. And unfortunately, the Democrats' legislation, H.R. 1 or S1, it mandates automatic voter registration, but it doesn't mandate any of the safeguards be built in to ensure mistakes like that don't happen. These kinds of issues also undermine public confidence in our elections, which we should be working to promote. We should be supportive of safeguards like voter ID that do not make it more difficult for people to vote, but it does make it more difficult for people to cheat. The success of our elections is reliant on the trust voters place in the system. So if we're exploring ways to ensure more people vote, I think it would be good to have a discussion about how the level of confidence people have in the accuracy of our voting system can impact people's choice to vote or not. With that, Mr. Chairman, I thank you and I look forward to today's hearing. I yield back.
Thank you, Mr. Style. Thank you very much for your opening statement. I'm going to. I have two methods for unmuting myself, and so I thought I would go back to the original one. One way is to touch the space bar, but if you've got Microsoft Word in front of you, the space bar only spaces the line and does nothing with the muting. But anyway, thank you, Mr. Style, for your opening statement. Before proceeding, let me recognize the ranking member of the full committee, my friend, Mr. Rodney Davis, for any opening words that he might have.
Well, thank you, Mr. Chair, and I do want to commend you for the way that you're running this subcommittee. I appreciate the opportunity to have a wide variety of witnesses come in, and I'm very anxious to hear their testimony. I'm a little miffed at you, though, Mr. Chair and Mr. Ranking Member. I had no idea you guys were meeting together right next door to my office. If I would have known, I would have at least come and pounded on the window, do something to disrupt the meeting, but would always love to see both of you because I think it's a testimony to the bipartisanship that exists in this Congress that a lot of people don't see and the media doesn't talk about. So cheers to both of you for getting together to talk about issues. And thanks again, Mr. Chair, for letting us talk about the issues today. I want to echo a lot of the comments that Ranking Member Style mentioned. We believe H.R. 1 will be a disaster, not just for state and local governments to be able to administer their constitutional authority and run elections from the states and localities where they should be run. H.R. 1 is going to put in place different policies and procedures that we have seen have gotten many people into trouble. They think that they might be registered to vote, but unfortunately they're not. And when they go cast that vote, They're held to the same accountability that anyone else would if they knew. So we're talking here about voter ID. Mr. Stile, Ranking Member Stile, made great points in stating we have had record turnout in the last presidential election. But let's also not forget, we had record turnout in the election that was the midterm election of 2018. During those two election cycles, we in Washington failed to celebrate what we did right to make sure that we had that record turnout. We have failed to talk about what the American people prefer. And 75% of likely voters surveyed in a recent Rasmussen poll actually believe voter ID is necessary for a fair and secure election. Two recent polls show broad support among African Americans and other minorities for voter ID. Rasmussen found 69% of African Americans support voter ID, while another poll by the Atlanta Journal-Constitution finds 2/3 of voters in Georgia support voter ID. 82% of Arizona's voters support election integrity reforms, which includes stronger voter ID and voter roll cleanup. One of the recent hearings we had at the full committee in the last Congress was to talk about voter roll cleanup, where we had then Secretary of State, now Senator of California, Alex Padilla, not commit to us to take off already identified dead people from the California voter rolls. At some point, we've got to take a serious look at ensuring that the voter rolls that are used in every single polling place in this country are updated according to law. These are the types of things that this subcommittee has been debating. I'm glad to be here today, Mr. Chair and Mr. Ranking Member. And again, I'm really interested to hear the testimony. And I would ask unanimous consent, Mr. Chairman, to include some of these studies and polls that I just mentioned for the record.
Without objection, yes.
Thank you. Thank
Absolutely.
you, Mr. Chair. Yield back.
And thank you to the ranking member. Now, in just a moment, I will introduce today's distinguished panel, but before I do so, as a reminder to our witnesses, each of you will be recognized for 5 minutes. There is a timer on your screen, and I'm sure that you've seen it by now. There's a timer on your screen. Please be sure you can see the timer and are mindful of the 5-minute time limit. Your entire written statements will be made a part of the record, and the record will remain open for at least 5 days for additional materials to be submitted. And so I welcome each one of our witnesses. Joining us today are 5 very distinguished individuals. First is Dr. Lorna Atkinson of the University of New Mexico. The next is Matthew Campbell of the Native American Rights Fund. The next is Dr. Nazita, and I know I'm going to botch this, so please excuse me, Dr. Nazita Lujavardi, and she can correct it when it's her turn to speak, but thank you, from the Michigan State University. The next is Andrea Centino of the Mexican American Legal Defense and Educational Fund. And our final witness is Laurie Roman of the American Constitutional Rights Union. Dr. Lorna Ray Atkinson is a professor of political science, Regents Lecturer, and director of the Center for the Study of Voting, Elections, and Democracy, and the Institute of Social Research at the University of New Mexico. Dr. Atkinson is an internationally recognized expert in the area of election sciences, survey methodology, voting rights, election administration, public opinion, and political behavior. She has written over 50 articles and book chapters and dozens of technical reports, monographs, amicus curiae briefs, and other works on these topics. Now let's talk about Matthew Campbell. Matthew L. Campbell is a staff attorney with the Native American Rights Fund. Mr. Campbell, an enrolled member of the native village of Gambell on the St. Lawrence Island in Alaska, has litigated numerous constitutional and statutory claims on behalf of Native Americans in areas ranging from water rights to religious freedom and freedom of speech. In the area of voting rights, Mr. Campbell recently brought a successful challenge to a North Dakota voter ID law on behalf of the Spirit Lake Nation and Standing Rock Sioux Tribe. Next is Dr. Nazita Lujavardi. The doctor is a professor of political science at Michigan State University. She holds a PhD degree in political science from the University of California, San Diego, law degree from the University of San Francisco School of Law. Her research focuses on issues related to race and ethnic politics, political behavior, voting rights, and immigration. Her work has been published in numerous leading peer-reviewed journals and featured in a variety of media outlets, including The Atlantic, The New York Times, The Washington Post. Andrea Centeno is Regional Counsel in the Mexican American Legal Defense and Educational Fund's DC office. Andrea leads MALDEF's efforts to protect Latino voting rights, including through working to restore the vitality of Section 5 of the Voting Rights Act. She, Centeno, who previously served as a legislative staff attorney at the EAC, the Election Assistance Commission, holds a law degree from American University Washington College of Law. Lori Roman, president of the American Constitutional Rights Union, her diverse career exemplifies her expertise in management and public policy, strategic planning, and public relations. Formerly, she served as the Deputy Director, Chief of Staff of the White House Center for Faith-Based and Community Initiatives at the Department of Education, where she was responsible for strategic planning and management of resources to achieve the goals outlined in the President's management agenda. She also served as the Director of School Choice, Senior Advisor on Family Educational Rights at the Department of Education. She holds a Bachelor of Business Administration degree, a Master of Science degree in Administration. So each one of the witnesses will now be recognized for 5 minutes, starting with Dr. Atkinson. You are now recognized for 5 minutes.
Thank you. Chairman Butterfield, Ranking Member Steele, and members of the committee, especially my own Congresswoman, Teresa Ledger Fernandez, thank you for the opportunity to testify before you today. I am Professor Lana Atkinson from the University of New Mexico, and I study elections, voting behavior, and voting rights, and have written extensively on voter ID implementation and voter confidence. While most of the focus on issues related to voter ID policies has been on how they affect turnout, an equally important and alternative question to consider is whether voter ID policies are administered equally across groups. This is an important question because historically, laws like voter ID have been used to create barriers to participation and have been implemented unequally across segments of the voting population. In the case of voter ID, the effects of minorities might be more subtle and difficult to discern because these laws may not directly result in reduction in turnout, but may affect voter confidence and satisfaction in the election process, which may have long-term consequences on voter turnout or lead to increases in provisional voting. Several studies of poll workers and voters suggest that implementation practices can result in unequal implementation and application of voter identification laws. In my original study in New Mexico, we found that many voters were asked by poll workers for ID inappropriately, and that Hispanics and men were asked for photo ID more often than whites and women. In another study in Massachusetts, researchers found that Blacks and Hispanics were asked for photo identification at higher rates than whites. In subsequent studies in New Mexico, we have found various degrees of differences between whites and Hispanics, sometimes showing significant differences and sometimes not, but always showing the inappropriate requests by poll workers for photo ID. Unequal application appears to be related to the interaction between the poll worker, the amount of discretion that poll workers have, along with the complexity of the voter ID law, especially having different voter ID rules for different types of voters and having variety of rules that allow many different options for the type of ID that the voter can use and poll workers can request. For example, both New Mexico and Massachusetts had adopted minimum Help America Vote Act requirements that first-time voters who register by mail and did not include photocopies of valid IDs with their mailed registration forms were required to show a physical ID. In addition, Massachusetts required a physical ID for voters who were identified as inactive. Otherwise, for most voters, the minimum standard for voter ID in Massachusetts was the name and address of the voter, and in New Mexico, it was the name, address, and birth year. But it was the voter's choice, and they could also use a photo ID such as a driver's license, a Sam's Club card, their voter reg card, or a utility bill to identify themselves. This means that many states have the most accessible voter ID laws are the most likely to have problems with voter ID implementation. States that have easier to follow and consistent rules across voter ID have fewer problems with the application of policies, but of course, those states may have different impact on turnout. Why does this happen? It seems that poll workers do not always follow or appear to know the law. Poll worker studies indicate that poll workers are likely to misinterpret, misunderstand, or disagree with the voter ID laws, and therefore to misapply voter ID policies. Poll workers are temporary workers, working long hours a few times a year. They're often poorly trained, likely with no background in public policy or law. Consequently, when they are faced with the decision on how to apply policies to which they may be uncertain, they choose to require voter ID or not based upon their personal beliefs or normative judgments about what they believe those laws should be. Can this problem be resolved? While proper training can reduce poll worker discretion substantially, it likely cannot eliminate it. In addition, it is clear that the county clerk has to be continuously vigilant because without constant emphasis during poll worker training, discretion results in uneven implementation. In conclusion, it is important to note that many states have hybrid policies that have different ID requirements for different types of voters and offer many options for voter IDs. These laws are more likely to produce voter and poll worker confusion, allowing poll workers to set their own standards. As legislators and policymakers grapple with this issue, they should consider how the design of laws affects their implementation and what the means for creating uniform policies would be. Voters should be treated equally by their election administrators.
Thank you very much for that. We will now recognize Mr. Campbell for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Stiles and Davis, and all the members of the committee. My name is Matthew Campbell, and I'm a staff attorney at the Native American Rights Fund, also known as NARF. I'm an enrolled member of the Native Village of Gamble in Alaska and work at NARF's Boulder, Colorado office. NARF is the oldest and largest nonprofit law firm dedicated to protecting the rights of Native people across the country. I'm honored to address the committee today about the impact of voter ID laws on Native Americans. Native Americans have historically faced discrimination when attempting to vote. For example, the Arizona Supreme Court held in 1928 that Native Americans could not register to vote because they were wards of the federal government. That decision stood for 20 years. Utah and North Dakota were the last states to officially afford Native Americans the right to vote in the late 1950s. We have seen, however, that discrimination against Native voters still exists today in the form of voter ID. Native Americans face many obstacles to voting. They live in isolated communities, disproportionately far away from state governmental offices. They have high levels of poverty within their communities. They disproportionately lack access to transportation, and all over the West, they often lack residential addresses on their homes. These and other conditions make it extremely difficult to obtain basic governmental services like healthcare or government-issued IDs. For many Americans, obtaining identification is a simple act of going to the local DMV. But given the isolating conditions Native Americans live in, the high levels of poverty, lack of access to transportation, the distance to the DMV, the process is far from simple and in fact, severely burdensome. When faced with the option of paying for gas to travel 2 hours to a state DMV or buying food or diapers, Native people have little hesitation in choosing survival over a state ID. State IDs are often unnecessary for Native people in their everyday lives. They're able to get by just fine with their tribal ID. However, many tribal IDs do not have residential addresses on them because they often do not exist on the reservation. North Dakota is a perfect example. In 2011, the North Dakota legislature overwhelmingly shot down a very restrictive voter ID law because it would be burdensome to voters. The legislature heard testimony that Native voters in particular would be harmed by the laws given their lack of addresses. When the Native vote was instrumental in the 2012 elections, however, the legislature passed the most restrictive voter ID law in the nation in 2013. The law was limited to 4 forms of ID: a state driver's license or ID, a tribal ID, or a long-term nursing care certificate. The law required voter IDs to have a residential address on them. The problem was that many tribal members only had tribal IDs with no addresses or only a P.O. box because many homes on the reservation lacked physical addresses. The law required something that was often impossible to obtain. Elvis Norquay, who testified before this committee in February 2020, was one of the individuals that was disenfranchised by the law. He, like many Native people, had been in and out of homelessness, lacked access to transportation, and only had a tribal ID that did not have a residential address. But he had been voting in North Dakota for more than 20 years and knew all the election workers at his polling location. Because of the new and unnecessary law, however, he was denied the right to vote. Native people all over the country are in a similar position to Elvis. There are high levels of poverty. There is a lack of access to transportation. There are oftentimes no residential addresses on homes on the reservation. And governmental offices are prohibitively far away. These ultra-strict voter ID laws are unnecessary and disproportionately burden Native American voters. Sadly, Elvis passed away earlier this year. But we will continue to carry his message to Congress, a message that action is needed to protect the right to vote of all Americans, and especially the most vulnerable. Thank you, Mr. Chairman.
Thank you for your testimony, and I recall being part of the panel that went to North Dakota and heard the testimony of our dear friend, Norquay, I believe his name was. So thank you for making reference to that, and he will be missed without question. At this time, I'm going to recognize our next witness. This is the name that I fumbled in the beginning, and I'm certain I will fumble it again, but Dr. Lucia Varde. You're recognized for 5 minutes. I'm sure you've gone through this throughout your lifetime, so please forgive me. Thank you.
It's not the first time.
Yes.
Chairperson Butterfield, Ranking Member Stile, and distinguished members of the committee, it is an honor to offer testimony before this subcommittee today. My name is Dr. Nazita Lejavardi, and I am an assistant professor of political science at Michigan State University. I was asked here to provide my expert opinion on the effects of voter identification laws. My scholarly work over the past 4 years has in part evaluated the impact of voter identification laws on minority voter turnout in American elections. Across the board, my colleagues and I have found that these laws impose a disproportionate burden on minority voters. Our research consistently has found a negative and significant empirical link between voter ID laws and minority turnout in the United States. Voting is the most fundamental tenet of American democracy. Through the vote, citizens elect their representatives, they influence policy, and they participate in democracy. And importantly, any barriers to the vote should be carefully assessed to ensure that they do not significantly and systematically reduce the voices of marginalized groups, such as racial and ethnic minorities. Today, voter ID laws represent one of the nation's most important barriers to voting, and thus one of our country's most important civil rights issues. By raising the cost of voting for some individuals more than others, these laws affect who votes and who does not, and in doing so, they substantially shape whose voices are represented in our democracy. As of 2020, the National Conference of State Legislatures estimates that 35 states have laws in force that request or require voters to show some form of identification at the polls. What's more, these laws are becoming stricter and more common. I have co-authored 3 studies that directly examine the effects of voter ID laws on minority voter turnout. In each study, my colleagues and I have found a persistent, negative, and significant effect of these laws on minority voter turnout. Our first paper, which was published in the Journal of Politics in 2017, evaluated whether strict photo identification laws reduced turnout among registered survey respondents in a large national survey from 2006 and 2014. Our results from this study indicate that these laws serve not only to diminish minority participation, but also to increase the gap in the voter participation rate between white Americans and non-white Americans in our study. We have another paper that was published in Politics, Groups, and Identities in 2020. And in this paper, we changed course and used yet another methodological technique to evaluate whether voter ID laws affect minority turnout across US counties. In that paper, we focused on turnout changes across the 2012 and 2016 presidential elections, when Alabama, Mississippi, Virginia, and Wisconsin all implemented strict photo ID laws. Specifically, we looked to see if turnout in racially diverse counties declined more relative to turnout in predominantly white counties in those states that had enacted strict ID laws compared to those states that had not enacted strict ID laws over the same time period. And we found that turnout declined significantly more in racially diverse counties relative to less diverse counties in those states that had indeed enacted strict ID laws over that time period compared to the other states. I'd like to note that my scholarship on this matter is supplemented by a host of other scholars who have similarly found evidence of a negative effect of voter ID laws on minority turnout. And in addition to the evidence presented on the specific question of whether voter ID laws suppress the minority vote, it is important to highlight 2 additional points. First, minorities are less likely to possess valid forms of ID necessary to comply with these statutes. As such, the material burdens of voter ID laws fall harder on minority populations compared to their white American counterparts. Second, there's also some scholarly evidence demonstrating that minority citizens are also more likely than white Americans to be asked for identification at the polls. In closing my testimony, my professional opinion is that voter ID laws disproportionately reduce minority voter turnout and increase the gap between the voices of minorities and that of white Americans in American democracy. I suggest members of this committee address the undemocratic and disproportionate effect of these laws on racial and ethnic minorities in the drafting and passage of future voting rights legislation. Thank you very much, and I look forward to your questions.
Still having trouble with the mute button. Okay, ranking member, I'm still having a problem with the mute button. All right, thank you very much for your testimony. Next will be Ms. Centeno. You'll recognize for 5 minutes.
Good morning, Chair Butterfield, Ranking Member Steele, and members of the subcommittee. Thank you for the opportunity to testify today. My name is Andrea Centeno, and I'm the Regional Counsel of MALDEF's Washington, D.C. office. For over 50 years, MALDEF has worked to promote the civil rights of all Latinos living in the United States. Since its founding, one of MALDEF's top priorities has been securing equal voting rights for Latinos and promoting increased civic engagement and participation within the Latino community. Over the years, MALDEF has litigated numerous cases under Section 2, Section 5, and Section 203 of the VRA, challenging at-large systems, discriminatory redistricting, ballot access barriers, undue voter registration restrictions, and failure to provide bilingual ballot materials or language assistance. For almost 2 decades, Latinos have constituted the largest racial or ethnic minority group in the U.S. As the growth of the Latino population expands, states and localities have worked to slow the registration and participation of new voters, and thus MALDEF's work in voting rights continues to increase. As federal protections for voting evolve, policymakers seeking to limit the right to vote turn to alternative restrictions that restrict access to the ballot and which often disproportionately affect voters of color and language minority voters. In the last 2 decades, there has been an accelerating pattern of ballot access restrictions enacted to address baseless myths of widespread voter fraud. Increasingly restrictive voter identification requirements, proof-of-citizenship requirements for new registrants, and restrictions on how and when voter registration drives may occur are all state electoral changes seemingly implemented to stem the growing Latino vote in Texas, Arizona, and other states. In 2004, Arizona passed Prop 200, the nation's first statewide proof of citizenship mandate for registering voters. From 2000 to 2010, Arizona's Latino population increased by almost 600,000, reaching 30% of the state's population. Prop 200 changed the state's voter registration rule to require all new registrants to provide documentary proof of U.S. citizenship. And after enactment, more than 30,000 individuals had their voter registrations rejected by election administrators in Arizona. Prop 200 created significant burdens for new registrants, and of those with rejected registration, less than 1/3 subsequently registered to vote. The law also had a disproportionate effect on Latinos. The percent share of Latino voter registration in the state fell after the law was enacted, and evidence showed that Latinos made up a disproportionate 20% of those who did not manage to register after an initial rejection. And only 11% of Latinos who were rejected were successful in eventually re-registering. Meanwhile, the state failed to identify a single instance in which an undocumented immigrant registered or voted in Arizona. Nationally, more and more research confirms that instances of non-citizen voting are exceedingly rare. In fact, many non-U.S. citizens are hesitant to provide their personal information to the government and are afraid of the potential negative criminal and immigration-related consequences that may result from improper voter registration or voting. Proof of citizenship requirements have yet to prove effective in making our elections more secure or to be more effective than the safeguards against improper registration and voting that already exist. Meanwhile, such requirements have shown to significantly impede the political participation of voters of color. On the issue of strict voter identification requirements, Latinos and other voters of color disproportionately lack the identification documents required to register and vote, and they're more likely to be excluded because of this. Obtaining the requisite documentation can be a significant and oftentimes prohibitive expense. And for some registrants or voters, it requires travel to government offices, sometimes ones that are far away or inaccessible, waiting in lines and waiting for documents to be received. The growing Latino population is often seen by the political establishment as a threat in many places. As a result, we are likely to see an increase in efforts to disenfranchise the Latino electorate, including many naturalized citizens, and to limit the influence of our votes. Congress must take action to adopt and strengthen policies and laws that protect and encourage the participation of each eligible voter. Thank you, and I look forward to your questions.
Thank you for your testimony. At this time, the chair recognizes Ms. Roman for 5 minutes.
Good morning, Chairman Butterfield, Ranking Member Stile, and members of the committee. Thank you very much for this opportunity to testify. I'm president of the American Constitutional Rights Union and ACRU Action Fund. It is important that we address the duty to ensure access to the ballot box while also protecting the integrity of the voting process. Put bluntly, we should all agree to work together to make it easy to vote and hard to cheat. Some of my remarks today refer to an article in the Yale Law and Policy Review called The Other Voting Right, Protecting Every Citizen's Vote by Safeguarding the Integrity of the Ballot Box. This article was co-written by a colleague of mine, former Ohio Secretary of State and U.S. Ambassador to the United Nations Human Rights Commission, J. Kenneth Blackwell. Unfortunately, his schedule did not permit him to be with us today. Our country has spent many decades advancing the rights of citizens to fully participate in our republic. And this, unfortunately, has always been a fight between the political factions. First, we fought quite literally for freedom for all Americans. And after the Civil War, a war in which my great-great-grandfather was a Union soldier who was wounded and imprisoned at the notorious Andersonville prison camp, the 14th Amendment to the Constitution was ratified, giving citizenship to persons born or naturalized in the United States, including former slaves. This was passed by Republicans with no Democrat support. For Black American men, the right to vote came with passage of the 15th Amendment in 1870. The amendment passed with Republicans supporting the right to vote and Democrats blocking that right. Despite the amendment, Black Americans endured violence, intimidation, literacy tests, poll taxes, designed to block them from voting. These actions were committed mostly by Southern Democrats. In 1920, women were finally granted the right to vote with the 19th Amendment, and that was pushed and passed by a Republican-led House and Senate. As Americans, sometimes we have fought each other on this, but we should be proud that we fought hard for freedom and for access, and now it's time to fight for voting integrity to protect every person's vote from being diluted by fraudulent votes. Today, we'll talk about voter rolls that must be kept updated according to federal law and voter identification, which is a popular solution used throughout the world. The National Voter Registration Act, or Motor Voter Law, makes it easy to register people to vote, but it also mandates procedures to update the registrations from those who have moved or died to ensure accurate rolls. Unfortunately, the rolls across this country are filled with the names of people who have moved, died, or are not U.S. citizens. Over the years, my organization has brought lawsuits against counties which have ignored the law. In one county, ACRU found that not one single person that had moved or died had been removed from voter rolls for 3 years. Some people have tried to assert that clean voter rolls are racist. But moving people from the voter rolls who have moved or died has nothing to do with the ethnicity of the voter. As for voter ID, it seems to me completely unnecessary to make the case for something so common sense and used throughout the world. In fact, polls repeatedly show that Americans of all ethnicities support voter ID, and it is in many state laws. I quote the Yale Law and Policy Review article. States have significant authority under the Constitution to protect legal votes from illegitimate dilution. In 2008, a plurality opinion of the Supreme Court asserted that if a state's burdens on voting are merely inconvenient, and if its restrictions are non-severe and non-discriminatory, those burdens are evaluated under a much less demanding, important regulatory interest standard that is deferential to policymakers' judgment. Some members of Congress have maintained that requiring voter ID is racist, yet members of Congress voted for the Affordable Care Act. This legislation forces every single American to obtain health insurance. Compared to receiving free identification from the government, the process of purchasing medical insurance is complicated, expensive, and often daunting. Congress also added a financial penalty for those who didn't obtain insurance, increasing that burden. A few weeks ago, Black leaders signed a letter urging members of Congress to de-escalate their rhetoric, equating voting integrity with Jim Crow. One signer of this letter, Lieutenant Governor Mark Robinson, the first Black Lieutenant Governor of North Carolina, testified before the House Judiciary Committee saying, "The notion that Black people must be protected from a free ID to secure their vote is not just insane, it is insulting." In conclusion, the rights of American citizens to vote and to also have their vote protected from dilution by fraudulent votes is codified into federal and state laws, supported by Americans and grounded in common sense. Thank you for the opportunity to speak to you today.
Thank you, Ms. Roman, for your testimony. That concludes the testimony of the witnesses. We will now move into member questions. And it looks like from my list, Mr. Aguilar, you should go first. You're recognized for 5 minutes.
Thank you, Mr. Chair, and I want to thank the ranking member Style as well for putting this panel together and this hearing on the books for us. First, I wanted to start with Dr. Lajavardi. As you know, voter ID laws can take on a variety of forms, and you've talked about this. Some states, for example, require that voters present a photo ID, while other states request but do not require identification. Does your research provide any insight into whether particular types of voter ID laws have greater or lesser impact on turnout of minority voters?
Thank you so very much for asking this question, for allowing me to offer some of my research. Our research has mostly looked at strict ID laws compared to other laws. As you know, the strictest types of ID laws were introduced in 2006 in Indiana, and then in 2008 in Georgia. And so what our research has done is really looked at the effects of these strict ID laws for the most part, a comparison to their counterparts. And so the results that I spoke about in my written testimony and also in my oral testimony refer to the strictest forms of these laws.
I appreciate that. And can you speak to the harm that this question can impose on minority voters?
Certainly. I can draw from my testimony. In my first paper in 2017, we found that in general elections, Latinos in our survey were 10% less likely to turn out in states with strict identification laws than in those states without strict ID laws, all else equal. And these effects were almost as large in primary elections, where a strict ID law could be expected to depress Latino turnout by 9.3 percentage points, Black turnout by 8.6 points, and Asian American turnout by 12.5 points. And so given the already low turnout of most of these groups across the country, these declines are all the more noteworthy. I want to say one thing, if I may, about the gaps as well. So these laws don't only diminish minority participation in the survey sample that we were looking at, but they also increase the gap in the participation rate between whites and non-whites. So for instance, for Latinos, the predicted gap more than doubled from 4.9 percentage points in states without strict ID laws to 13.5 points in states with strict photo ID laws in general elections. And it more than tripled from 3.4 points to 13.2 points in primaries. And I can go on and on with respect to other racial groups, but I think that might paint the picture.
Thanks, Dr. Lativardi. Ms. Centeno, research has shown that proof of citizenship laws disproportionately hurt Latino and Hispanic voters who face a difficulty in obtaining documentation of citizenship, like a passport. These documents are often costly and could require taking time off of work to get these documents. And several states provide a proof of citizenship or have proof of citizenship laws that have been found to be preempted by the National Voter Registration Act. Yet oftentimes litigants, it takes several years to obtain a judicial ruling striking down these laws. What can Congress do to make it easier for litigants to obtain timely and effective relief from unlawful proof of citizenship laws?
Thank you for that question, Representative Aguilar. So one thing that Congress can do is work on legislation to restore the Voting Rights Act. As you have mentioned, litigation is costly and time-consuming, and it can take many years in some instances to get a resolution that allows voters to be able to access the right to vote freely and fairly. And so one thing that Congress can and should do is work to ensure that we are doing all that we can to enact legislation that restores the Voting Rights Act as a way to ensure that those localities, those states that are most likely to engage in discrimination with a history of discrimination, and that those practices that are most often used to discriminate against voters of color can be addressed before the election change takes place. In addition to that, there is legislation within the HR 4, the Voting Rights Advancement Act, that addresses how to also make litigation more accessible and more timely for those private litigants who want to challenge voter laws that may not be included or may not be covered by the preferred formulas. And so those are things like addressing preliminary injunction standards.
Thanks, Ms. Centeno. I appreciate it. Before my time's up, Mr. Chairman, I'd like to seek unanimous consent to enter into the record 3 reports focusing on the harms of voter ID laws into the record. The first by Mr. Barreto, who's on our second panel. The second by Ms. Hanjal, voter identification laws and suppression of minority voters. And the third titled A Disproportionate Burden, Strict Voter Identification Laws and Minority Turnout.
Without objection. Thank you. Thank you, Mr. Aguilar. Do you yield back, Mr. Aguilar?
Yield back,
Right.
Mr. Chairman.
At this time, the chair will recognize the chairman of this, the ranking member of the subcommittee, Mr. Stile.
Still the ranking member, but thank you very much, Mr. Chairman. I
Yes.
appreciate you having today's hearing. Unless you want to hand me the gavel, but I'm guessing not.
Keep hope alive. Yes.
Let me dive in the short time I have. We heard a couple folks speak in their opening remarks regarding equal implementation. I think it's an important topic to bring up. And I think we've actually seen in other areas where photo ID is used, equal implementation being an issue, but also being addressed. In fact, every time I go through TSA, to the best of my knowledge, every single person has to show their ID. In fact, I grabbed a 6-pack of beer at Walmart the other day. The cashier recognized me, said, "Hello, Brian," and then asked for my ID. In the state of Wisconsin, every single person is asked for their ID, I think in part to remove any sort of disproportionate impact to any given group of individuals. It seems like a reasonably straightforward solution to address some of the challenges that may have been brought up in some of those opening comments. I think the private sector has addressed that, and I think it's maybe something other states outside of the state of Wisconsin might want to look at. Let me dive in to Ms. Lori Roman, if I can. Do you believe voter ID increases confidence in the integrity of the election process?
Yes, and I believe one of the other presenters presented that Americans overwhelmingly agree with it, of all ethnicities. So it increases integrity, and it also ensures that every single person's vote is not diluted by fraudulent votes. So every person of every ethnicity should desire to not have their vote diluted by a fraudulent vote.
Let me follow up. In your testimony, you quote from a Yale Law and Policy Review article authored by the former Ohio Secretary of State. In that, he said discriminatory intent is the key determination for voter ID laws. In your opinion, do voter ID laws have a discriminatory intent?
No, if applied, as you indicated, if applied to everyone, and without any subcategories, the Supreme Court has already looked at this. So in 2008, plurality of the Supreme Court asserted that if a state's burdens on voting are merely inconvenient, and if its restrictions are not discriminatory, those burdens are evaluated in such a way to defer to the policymaker's judgment.
Thank you. I'm gonna jump now over to Dr. Nazita Lajavardi, if I can, for a moment. Two of your studies use self-reported data about the impact of voter ID on the propensity to vote. Yet there's been other studies using actual turnout data that have found that there was not a difference in turnout in states based on voter ID. Would your data, do you think, have been different if you had used empirical data rather than self-reported information?
Thank you for that question and for giving me a chance to respond. So our first two studies looked at survey data from a nationally representative.
And I don't want to be rude. You can add things into the record, yeah, but I'm limited I got 90 seconds left.
Sure,
do you think it would have been different? Yes or no?
So our third study did show the same effect, and that was based on aggregate levels.
So in your opinion, you don't think it would have been different if self-reported to the empirical data. The second question. So in your third study, you looked at turnout changes between 2012 and 2016 in 4 states, and according to your testimony, it compared racially diverse counties in those states against majority white counties. Your study compared voter turnout in racially diverse counties in those 4 states to racially diverse counties in states that did not implement strict voter ID laws, and how they would compare. Question, in your analysis and in your model, did your study take into effect variables that could affect turnout, and in particular, such as having a historically bad candidate like Hillary Clinton?
That was not a variable that we controlled for, but we did control for other statewide covariates that might have been.
So you did not control for the difference maybe between a Barack Obama and, in my opinion, a historically bad candidate like Hillary Clinton on the impact of minority voter turnout?
We simply just looked at the differences in voter turnout in those counties in 2012 and in 2016.
I will not declare that I have a PhD in statistics, but I can tell you from an empirical data standpoint, just walking around and talking to people in many of these types of communities, that might very well be a worthwhile thing to look to see if you can control for, because I think it's going to show up in the empirical data. And so with that, Mr. Chairman, looking at the time, I appreciate you giving me the opportunity, and I will yield back.
I thank the ranking member. And this time the chair recognizes Ms. Ledger Fernandez for 5 minutes.
Thank you, Chairman Butterfield, for holding this important hearing, and thank you to our witnesses for being here to shine a light on the barriers we face today with actual data rather than anecdote. Mr. Campbell, I am very appreciative to you providing the panel with a history of the repression of Native American voters. In New Mexico, where I litigated some of these cases, you know, it wasn't until the 1960s that Native Americans won the last court case saying they had the right to vote wherever they lived. I found it interesting the way you tied historic discrimination of Native American voters to voter ID laws today with the example from North Dakota, where precisely because of high Native American voter turnout, we then saw these more restrictive voter ID laws, because I think that's what we're seeing today. So I appreciated that. Mr. Campbell, Do you think you could respond a bit to the questions that we've been hearing, as well as the idea that this is not a problem and should not be considered a problem, the issue of voter ID, and then maybe tie that to why litigation is not the solution, that we should try to find a solution to it otherwise, for example, in Congress and in some of our laws?
Yes, thank you, Representative Fernandez. I think absolutely we see in Indian country, it is a problem. With the high levels of poverty, the distance it takes to get to the DMV, lack of access to transportation, there absolutely is a disproportionate burden on Native voters through the requirement of strict voter ID laws. And the federal district court found many facts that supported this evidence. And so I think it absolutely is a problem that is needs to be addressed. In terms of utilizing litigation to address the problem, it's extremely costly and very time consuming and very complicated to bring litigation to try and change this problem and require more forms of broadly accepted IDs like a utility bill, a bank statement, or even a letter from the tribe that says that voters are qualified and live within the district. So I do think it's not the best solution to the problem given its cost and expense, but it's certainly, voter ID is a problem for our new country.
Thank you, Mr. Campbell. I want to also turn to Dr. Atkinson with the University of New Mexico, making us proud here today. But your research found that election officials can administer facially non-discriminatory election laws in a discriminatory manner, right? As a Nuevo Mexicana, I read with concern the idea that even in New Mexico, where we actually have a history of higher participation by Hispano voters, that, as you put it, the local street bureaucrats would ask Hispanos for ID more often than non-Hispanos. Could you describe what factors contribute to that?
Sure. So the factors that seem to contribute to that are the very complicated laws that we have that allow different types of voters to give different types of IDs, and the fact that different types of voters are required different IDs. So new voters, for example, who haven't voted before, have to show a physical form of ID. So some voters do have to do it. And once you have sort of, a setup like that, it creates more complications for both voters and for poll workers. What are they supposed to do? And when in doubt, poll workers rely on their own sense of what they should be doing, what their own normative judgments are about giving ID or not, and how they decide to do that.
So HR 1 allows voters to certify their identification under penalty of perjury. Now, would a uniform application like this address the unequal treatment and barriers you've identified?
I believe so. I think if you had, a single criteria, that would suggest that would be a way to move forward to create uniform policies across voters. And
this could be to the panel, but perhaps Mrs. Centena. Ranking Member Steele said that higher voter turnout in 2020 shows that voter ID laws don't deter people from legally voting. Do any of you have a response to this assertion? Was it that the voter turnout doesn't matter? I see I've run out of time, but real quickly, perhaps a real quick answer. Selena.
I'll answer very quickly and say that, evidence is showing, more studies are coming out that demonstrate that these voter ID laws do restrict Latino voters. And as we increase as a share of the electorate, the more and more people who are prevented from voting, even if voter turnout is not taking a dip, if that share of the Latino electorate is not increasing, then studies we see are showing that that's the case.
Thank you. And Mr. Chair, as my time has come to an end, I would like to request unanimous consent to enter into 2 documents into the record. The first is a new barrier to participation, heterogeneous application of voter identification policies by Dr. Atkinson. The second is obstacles at every turn by the Native American Rights Fund.
Without objection, both documents will be received.
Thank you, Mr. Chair. I yield back.
I thank the gentlelady. At this time, the chair will recognize Mr. Davis, the ranking member, for 5 minutes.
Thank you, Mr. Chair, and thank you again to all the witnesses. Great to hear from many of you. First off, Ms. Roman, there's been a lot of talk about voter turnout. And again, as I mentioned in my opening statement, I think it's tragic that we don't talk about the good things we're doing in this country that led to historic midterm turnout in 2018 and in 2020 across all demographics. Instead, we talk about what divides us and what could lead to lower turnout in the midst of historic turnout. Now, taking a look back at history, I know you mentioned some historical facts during your opening statements, Ms. Roman. I want to ask you a quick question. Was voter turnout, did we lose her? Impeccable timing. There you go. You back?
I'm back.
Ms. Roman? Okay. With the initial Voting Rights Act that passed with Republicans leading that in the 60s, could you tell us if voter turnout was used as part of maybe determining what a covered jurisdiction would be? I'll go ahead and answer for her if she keeps losing her.
Okay, there, I heard you this time. Could you just repeat the question quickly? I'm sorry.
Was voter turnout utilized in the initial Voting Rights Act to determine what covered jurisdictions would be covered under?
I am not aware whether it was or not. I'm sorry.
It was. It was the main driver, the voter turnout for the presidential race in 1964 was utilized. So voter turnout has been part of determining what works and what doesn't work. Actually, let me move on to Ms. Centeno. And Ms. Centeno, I appreciate your work that you're doing on behalf of Latino voters all throughout the country. And it's not just about voter turnout, it's about having Latino representation, right, in Congress. Is that true?
So that's one, sorry. In terms of voting rights in general, representation is certainly one thing that MALDEF works to increase through the litigation that we bring, that may be through litigation against at-large systems or discriminatory redistricting, or in other instances, other cases that deal with the ability to elect. So representation is one aspect of that, but when we're talking about voter ID laws and ballot proof of citizenship requirements, really the focus there is the studies and evidence that show that Latinos are hampered by their ability to cast their ballots because of these restrictions.
Well, we've seen historic turnout and historic voter participation graphics, and I certainly hope that continues. And I certainly hope that MALDEF plays a role in touting some of the successes. And as you look ahead, though, redistricting is coming up. I hope MALDEF's concerned about a lack of Hispanic representation, maybe in states like Illinois. Are you engaged, or is your organization engaged to ensure that the growth of Latino voting population in my home state of Illinois is part of a possible new congressional seat, since Hispanics are clearly underrepresented in the Illinois congressional delegation?
So MALDEF does engage in redistricting public education, and when necessary, will engage in litigation to address redistricting plans that are discriminatory. And so MALDEF does have a regional office in Illinois, and we are engaged in public education efforts to make sure that community members are aware of the redistricting process, how it works, and how they can be engaging and advocating for their own communities as Illinois and local jurisdictions redraw their district lines. And that's an activity that we engage in across the country in many different locations, including Texas and California. And we'll be engaging with our partners on the ground to make sure that community members are empowered with information. But in addition to all of that work, yes, where necessary, MALDEF does bring litigation when redistricting plans are discriminatory.
Would you consider it necessary to have a lawsuit or put forth litigation if there's one Hispanic member of Congress from the state of Illinois with, I believe I've heard the statistic, 40% increase over the last decade of voting age Latinos, and only one Hispanic district?
I think it would certainly be too early for us to commit to what we might do in terms of litigation or litigation strategy with respect to a redistricting plan in Illinois. Even in the scenario that you have just described to me, we obviously would take it under consideration and look closely at what that districting plan looks like and how it included or how it addressed the Latino community throughout Illinois and in those pockets where there are significant Latino populations.
Yeah, we'll look very closely too at equal representation of litigation in Democratic versus Republican-led redistricting states too. Thank you again for your responses. Thanks to everyone, and Mr. Chair, I yield back.
Thank you very much, Mr. Davis, and thank you, Rodney, for making reference to the 1965 Voting Rights Act. I remember it so very well. I had just finished high school a few weeks before the VRA was passed. And as I recall, one of the most significant parts of the VRA, as you said, was that the legislation was bipartisan. Democrats and Republicans came together and passed the VRA. It was supported and demanded actually by President Lyndon B. Johnson at the time, right after the Selma to Montgomery massacre. So thank you for bringing that up. I looked it up a moment ago. It looks like only 74 members of the House voted against it. 328 members supported it on August 3rd, 1965. So thank you for mentioning that fact. It's something we're very proud of. At this time, the chair will recognize the gentlelady from the suburbs of Philadelphia, my friend Mary Gay Scanlon, for 5 minutes.
Thank you very much, Chairman Butterfield, for the opportunity to examine the facts about strict voter ID laws, or as our colleagues said, the reality of the impact of those laws. As a representative from Pennsylvania and someone who spent decades representing voters seeking access to the ballot, we recently lived that reality, and I saw the detrimental impact of strict voter ID laws firsthand. Unfortunately, voter ID requirements that may seem like common sense to some turn out to have a serious anti-democratic impact in practice. So I welcome the opportunity to examine the perception that voter ID laws are neutral or even necessary when in fact the reality is different. In March 2012, Pennsylvania's then Republican governor signed into law a bill passed by our legislature, which at the time was all Republican, which mandated that voters provide certain types of identification each time they voted. So it imposed strict new restrictions on the types of eligible identification. Under this new law, the lead plaintiff in the case which ultimately succeeded in overturning that law was Viviette Applewhite, a 92-year-old African-American woman who had voted in every election since 1960. She would have been unable to cast her ballot in 2012. Despite having worked for our country as a welder during World War II, marched with Dr. Martin Luther King during the Civil Rights Movement, etc., she did not at age 92 have a valid driver's license and at the age of 92 lacked access to her birth certificate. Her story was the same as hundreds of thousands of Pennsylvanians who, due to circumstance, age, or ability, lacked the types of ID which were newly required. In fact, expert testimony at the trial established that more than 500,000, or more than 6% of Pennsylvania's registered voters lacked the types of ID required by the new law. And for context, the number of voters who would have been barred from voting in 2012 was more than 6 times the margin by which President Biden beat the former president in Pennsylvania in the 2020 election. So as for the statement that voter ID has no discriminatory intent, we also saw that that wasn't true in Pennsylvania. Republican leadership bragged on tape that the strict voter ID law was one of the legislative victories his caucus had chalked up in its efforts to flip the state's electoral votes for the Republican candidate in the 2012 presidential election. And in fact, the data in the report offered as expert evidence at that trial showed that 3 times the number of Democrats and independents would have been disenfranchised by that law as would have been Republicans. Nationally, we know that 11% of Americans lack the type of identification mandated by strict voter ID laws, or at least of the type that were signed into law in Pennsylvania. The time, fees, and documentation required to get these IDs are insurmountable for many Americans, especially older Americans, folks with disabilities, and depending on the nature of the ID, also students and married women. So I saw that firsthand as I helped to organize and participated in free legal clinics to assist thousands of Pennsylvanians to obtain ID before that law was struck down. And we knew that we couldn't reach tens of thousands of others. So as we consider proposals to protect the integrity of our elections, it's imperative to weigh the facts. In other words, the actual benefits, which remain extremely speculative, against the very real harm of such laws. And it's also why I support the practice-based pre-clearance provisions in H.R. 1, the For the People Act. So, Dr. Lajarvardi, you've conducted several studies analyzing the impact of strict voter ID laws on minority voters. Can you just talk about the implicit bias of the types of ID that are chosen? For example, driver's licenses when you have populations that don't drive, birth certificates when you have a history of a population that perhaps had at-home births, hunter's licenses as opposed to student IDs.
Yes, thank you so much. What I will say is that no two state has the same voter ID law. And so the requirements of each of these state laws that are constantly being introduced, passed, or not passed, or they vary from state to state. And so there's a great deal of confusion that comes along with them. There's a high cost for actually knowing what kinds of laws individuals need to bring to the polls. I myself have not exactly studied this, but I will point the subcommittee to a paper by Bernard Fraga and Michael Miller that is forthcoming in the Journal of Politics, where the authors look at a case study in Texas, which had implemented a strict voter ID law in 2014. But then a last-minute federal court decision allowed Texans without qualifying documents to vote in the 2016 election. And what they found was that 16,000 Texans who would have been disenfranchised for lack of compliant ID were able to vote in 2016 because of this change. And when asked why they were not, they didn't have the right type of ID, the authors found that individuals actually many of them had their licenses taken away. Many had moved and hadn't gotten proper ID, Texas ID. And so there is a number of reasons for why individuals would not have the right kind of ID to participate in a given election.
Thank you. And I see my time has expired. I would just seek unanimous consent to introduce into the record the memorandum opinion of Judge McGinley in the Pennsylvania case, Applewhite versus the Commonwealth of Pennsylvania, that outlines the judge's findings in support of his decision that the strict voter ID law in Pennsylvania was an unconstitutional restriction on voters' rights. I yield back.
Without objection, this memorandum will be received. Thank you very much, Ms. Scanlon. At this time, the chair will recognize himself for 5 minutes, and I begin with Dr. Atkinson. Again, Dr. Atkinson, thank you for your testimony. To my satisfaction, it has been demonstrated time and time again that voter ID laws disproportionately impact racial minorities. Certainly, it may impact a lot of people, but it disproportionately impacts racial minorities. That's a fact. My question to you, Dr. Atkinson, is what can we do? What can Congress do to reduce the risk that voter ID laws will be administered in a discriminatory manner?
Well, creating uniform policies across states would be one way to create consistency, probably the best way.
Is there a significant disagreement among the nonpartisan experts that voter ID laws disproportionately impact racial minorities?
I think there's some papers that show different effects. Some papers show, so there are various papers that show different things, depending on how you look at it.
And let me move to Matthew Campbell. Mr. Campbell, you have successfully litigated, I'm told, to protect Native Americans, almost said Native African Americans, but you have litigated to protect Native Americans from discriminatory voter ID laws. What are the unique circumstances facing Native American voters that render strict voter ID laws particularly burdensome?
Thank you, Mr. Chairman. I think one of the biggest things that we saw in North Dakota was the requirement of a residential address, when many homes on the reservations in North Dakota just simply did not have a residential address. So it was a requirement that was essentially impossible to comply with. The other things we see are the high levels of poverty on many reservations, the lack of access to transportation, and the disproportionately long distances to government offices like the driver's license sites or DMVs. All of these things place a disproportionate burden on Native American voters to obtain voter IDs.
And thank you for that, Mr. Campbell. I recall a couple of years ago when we held this hearing out in North Dakota, there was an abundance of evidence from that community that that so many people do not have reservation addresses, and how that discriminates against them and prevents them from having the ID that the law requires. So thank you for including that in the record again today. Let me go over to the professor from Michigan State University. Some studies of voter ID laws have found that these laws do not necessarily disproportionately decrease turnout of minority voters. Yet your research has found that strict voter ID laws do appear to have different effects by race and ethnicity. Help me, what is the explanation for these different results?
Certainly, thank you for asking that question. So there have been a myriad of studies that have begun to study the effects of voter ID laws, beginning in the late 2000s through present day. In the late 2000s, the early studies that came about looked at the influence of these ID laws before the strictest types of laws were actually introduced into state legislatures. And so, you know, scholars really did not have a chance to actually understand the breadth of these voter ID laws. What's different about our research is that now, by the time that we do our studies, 51 elections have passed, federal elections have passed, in which we can actually assess the impact of voter ID laws over time. And certainly, as more data has become available, more scholars are studying this question. And while each of these data sets or each of these scholars and papers are approaching the question differently, what you can see is a consistent negative effect on voter turnout. Now, sometimes our estimates are small, sometimes they're larger. It depends on how you slice and dice your data. But my read of the summary, my read of the literature and my summary of it is that these laws do in fact pose a disproportionate, negative, strong, consistent depreciation of minority votes.
Thank you very much for those responses. I'm going to conclude at this time and yield back the balance of my time. Let me thank you. The member questions are now concluded. And I want to thank each one of the members of the first panel for your testimony today. It has been very, very enlightening and will become a very integral and important part of this record. So thank you very much. We are now going to move to our second panel of witnesses. Joining us today, and I hope they are all in place, and let me ask the staff, are they all in place? They are. Joining us today on our second panel are Dr. Matt Barito of the University of California, Los Angeles. I cannot pronounce that. Terry is pronounced, please forgive me, staff, help me on the last name. Menace. Terry Menace is with the Asian Americans Advancing Justice entity. It's AAJC. The next witness is Cara Romero Kraft. She is with the Latino Justice Organization, PRDELF, right? Okay. And finally, I should have rehearsed this before I started, Mr. Ranking Member, but our next witness is Harmeet Dillon of the Dillon Law Group. Dr. Barito is Professor of Political Science and Chicano and Central American Studies at the University of California at Los Angeles and founder of the Research Center Latino Policy and Politics Initiative. His research examines the political participation of racial and ethnic minorities in the United States, and his work has been published in numerous leading scholarly journals. In addition to his research on Latino voting patterns, Dr. Perito has conducted extensive research on voting rights. He has been an expert witness in numerous voting rights lawsuits. Terry Menace is the Senior Director of Census and Voting Programs with the Asian Americans Advancing Justice Organization. She is a widely respected authority on voting rights. She was one of the key leaders in the campaigns to reauthorize the Voting Rights Act of 2006, and I've been in Congress long enough to remember and have participated in that. She was a key leader in the campaign to reauthorize the VRA in 2006. And I might say to my Republican friends, it was Mr. Sensenbrenner. Mr. Style, you know that very well. It was Mr. Sensenbrenner and President Bush and others who embraced the 2006 the reauthorization. And so that too was bipartisan. But also the Supreme Court's decision in Shelby County versus Holder, she was very much a part. Ms. Menace has published several articles, chapters in all 4 editions of the ABA's Elections Handbook, and has been counsel on numerous amicus briefs filed before the Supreme Court on voting rights cases. Kira Romero Kraft. Kira is the managing attorney for the Southeast Office of Latino Justice PRDLEF. I always have trouble with that, PRDLEF. Her work focuses on immigrants' rights, voting rights, economic justice, and criminal justice reform. In the area of voting rights, she successfully litigated to compel the Florida Secretary of State, an election supervisor in 32 Florida counties, to provide Spanish language voting materials to Spanish-speaking voters educated in Puerto Rico. Next is Harmeet Dillon. Harmeet is the founding partner of the Dillon Law Group Incorporated. Dillon's broad experience also encompasses securities and entertainment, employment discrimination, and civil rights matters. Dillon also represents clients across California in election and campaign law matters, ranging from general compliance and ethics representation for partisan and nonpartisan contenders to ballot description contests, and that is a big deal in California for those of you who are not aware. She is regularly retained by candidates in campaigns for advice on complex legal issues. Dillon is a graduate of Dartmouth and the University of Virginia School of Law. I'm going to recognize each of the witnesses for 5 minutes, and we will begin with Dr. Burrito. You're now recognized.
Thank you to the committee for the invitation to speak today. The matter of free and fair elections is the bedrock of our democracy. My name is Matt Barreto, and I'm a tenured professor at UCLA, where I am also the director of the UCLA Voting Rights Project. I have researched access to voting for more than 15 years and provided expert reports and expert testimony in 7 different state and federal cases related to voter identification laws. Across these states, my reports have been credited by both Democratic and Republican appointed judges as providing clear and accurate data on the impacts and the burdens of voter ID laws. I've also examined the national trends on access to voter identification and underlying documents, and I've published numerous peer-reviewed scholarly articles and book chapters on the topic of voter access and voter identification laws. Every single adult American citizen who is eligible to vote should enjoy an equal access to the ballot. It should not be harder for some citizens to vote. We should not erect more barriers for just some citizens. Americans who are eligible to vote should be able to register and cast their ballot without undue obstacles and burdens. And as you have no doubt heard, there is no widespread threat of voter fraud in our elections. This topic has been thoroughly analyzed by political scientists, government commissions, and independent researchers. And the conclusion has been overwhelming, that our elections are free and fair, and the allegations of voter fraud are a myth. In response to this hypothetical myth of voter fraud, some states have enacted strict photo identification requirements for voting, often called voter ID laws. In 2006, as the voter ID debate was being implemented and debated, I began to study the consequences of such laws. From a combination of analyses using official voter files, state ID databases such as driver's license records, and validated public opinion surveys, there is an unmistakable trend. Black, Latino, and immigrant communities are statistically less likely to have a valid ID for purposes of voting as compared to white, non-Hispanic populations. What's more, in many states, the ID laws have specific rules and caveats, so many people wrongly believe that they have a valid ID and do not attempt to navigate the bureaucracy to get a new one. For instance, an expired ID does not count in most states. The name on the ID must be an exact match, no nicknames or changes due to marriage. The address listed must be an exact match, and PO boxes are often not allowed. And there is a maze of which exact ID counts. In many places, even official IDs issued by a government agency, such as a university school ID or social services IDs, library cards or others, do not count. So for millions of Americans who do have some sort of ID, they are excluded from voting because strict and specific rules in their specific state. But then there are millions of people who just don't have any sort of government-issued photo ID in the first place. According to the 2019 Census American Community Survey, 8.5% of all households do not have any car or vehicle available. While driver's licenses seem ubiquitous to those of us who fly back and forth to the nation's capital, we have to put ourselves in the shoes of millions of Americans who don't own a car, have never been on an airplane, yet they have a right to vote without undue burdens. And these burdens fall disproportionately on Black, Latino, and immigrant communities. Beyond voter ID laws, my report has also examined the importance of bilingual voting materials. According to data from the 2015 Census ACS, there are 10 million US citizens eligible to vote who do not speak English well, with the largest population being US citizens who are Latino at over 5 million. When it comes to language access, voting rights provisions are settled law. Where language minority populations reach thresholds, state and local jurisdictions must provide non-English access to all voting materials that are otherwise available in English. Research in political science has documented with clear evidence that access to Spanish, Asian, and Native or Indigenous language voting materials increase voter participation rates among impacted minority groups. These findings are consistent across all different language criteria. But similar to voter identification laws, the research has demonstrated an inconsistent application, with many covered jurisdictions not aware or not providing the proper non-English voting materials. This has a tremendously negative impact on those communities' ability to understand and participate in our elections. Thank you.
Thank you. Thank you very much. At this time, the chair recognizes Ms. Minutes for 5 minutes.
Good afternoon, Chairman Butterfield, Ranking Member Style, and members of the subcommittee. My name is Terry Almenis, and I am the Senior Director of Census and Voting Programs at Asian Americans Advancing Justice, AAJC. We are a national nonprofit, nonpartisan organization dedicated to advancing the civil and human rights for Asian Americans and building and promoting a fair and equitable society for all. One of our top priorities is the elimination of discriminatory barriers to meaningful civic participation by Asian Americans. I want to thank you for this opportunity to appear before the subcommittee today to provide comments on the Asian American electorate and how the language barrier and the lack of multilingual support impede our community's ability to achieve full political participation. Asian Americans have been the nation's fastest growing racial group for well over a decade. We have seen a similar increase among the Asian American electorate, with over 11.5 million eligible Asian American voters in 2020, a 150% growth over the last 2 decades. The 2020 election also showed a 27% increase in registered Asian Americans and a 36% increase in Asian Americans who voted compared to the 2016 election. At the same time, we once again saw the consistent double-digit gap with white voters for both voter registration and turnout that we have seen election after election. This persistent gap highlights systemic issues and barriers facing Asian Americans' free and fair access to the ballot. One of the primary barriers derives from the historical discrimination that denied Asian Americans the rights held by U.S. citizens for most of the country's existence, as federal policy barred immigrants of Asian descent from becoming U.S. citizens and from even being allowed entry into the country. Because immigration from Asia was not reopened until 1965, Today, over 2 out of 3 Asian Americans are born outside of the United States, with almost 3/4 of Asian Americans speaking a language other than English at home. Additionally, almost 1/3 of Asian Americans are limited English proficient, or LEP, and have some difficulties with the English language. As a result, a major obstacle facing Asian American voters is the language barrier. Navigating the voting process can be complicated and overwhelming, even for those who are fluent in English. When multilingual support is properly provided, civic engagement increases. When multilingual support is withdrawn or denied, language barriers are exacerbated, which leads to less voters participating in our democracy. LEP voters face threshold barriers to understanding the election process, such as how to register, locate their polling place, and learning about absentee and early voting options. Some will have immigrated from a country with vastly different democratic and voting systems. They may not be able to access election administration websites, which serve as a primary source of information for many voters because most are only in English. Telephone multilingual support is often also not a viable option for LEP voters. Even where there is bilingual staffing available that could provide multilingual help, it can be cumbersome and difficult to reach that staff person. If a voter can navigate all of that, they must next overcome challenges in casting a ballot. There is a higher risk of LEP voters encountering hostility from monolingual poll workers, including poll workers not familiar with existing laws about language assistance, such as Sections 203 and 208 of the Voting Rights Act. Additionally, ballots and other voting materials are often written in high grade level English, making it difficult for LEP voters to comprehend and respond. This can be compounded by higher levels of illiteracy rates, whether in English or in the LEP voter's original language. If an LEP voter, who may be a first-time voter as a newly naturalized citizen, has a bad experience when trying to vote for the first time, it stands to reason that they will not attempt to vote again without significant intervention and motivation by a third party. Ultimately, lack of multilingual support creates formidable hurdles for LEP voters. The history of discriminatory intent in denying language assistance shows that the lack of multilingual support has long been understood to interfere with a LEP voter's free and fair access to the ballot, and has been used for just that purpose. Thank you again for this opportunity to share our organizational views on this topic.
And thank you, Ms. Menace. At this time, the chair recognizes Ms. Romero Kraft for 5 minutes.
Chairman Butterfield, Ranking Member Stile, and members of the Subcommittee on Elections. My name is Kira Romero Kraft, and I serve as the Director of the Southeast Region for Latino Justice PRLDEF. That is correct, Ranking Member, Puerto Rican Legal Defense and Education Fund. Latino Justice led the way in ushering bilingual voting systems to the benefit of millions of language minority voters. Today, we use litigation and advocacy to protect those rights, to stop discriminatory purges of eligible voters, and to stem the dilution of Latino voting strength. Thank you for the opportunity to testify before you about ongoing discrimination and challenges faced by language minority voters in Georgia and Florida when they attempt to exercise their fundamental right to vote. It is of critical importance to ensure that language minority voters enjoy the full protections of the Voting Rights Act and any changes to improve those. I have been litigating cases brought under the Voting Rights Act, as well as leading our Cada Voto Cuenta, nonpartisan election protection, voter education, and poll monitoring activities since I joined Latino Justice at the Southeast office located in Orlando, Florida in 2017. As a result, I have experienced firsthand the complaints of voters suffering discrimination and also the pushback and outright opposition from certain election officials regarding full compliance with the language assistance requirements of the Voting Rights Act. In Georgia, we have seen Spanish language dominant voters who have not even been able to register to vote because there are no voter registration applications available in Spanish or assistance available, as well as not receiving updated information related to changes being made to the administration of elections in their preferred language. We've seen that in the 2020 elections as well as during the runoff elections. In addition, I would be remiss to not include the fact that Puerto Rican U.S. citizens were denied the opportunity to exchange their Puerto Rican driver license or identity document in Georgia for many, many years. And it wasn't until a recent settlement based on our litigation in the state of Georgia that allowed Puerto Ricans to enjoy the full privileges of all U.S. citizens. In Florida, we have fielded many complaints from voters, in addition to a voter in Lake County who wasn't provided Spanish language services in order to register to vote, voters in Osceola County who have had the police called on them because they were wearing a Spanish language t-shirt, they called the police to have them removed from the line when they were trying to exercise their right to vote, as well as an elderly voter in Miami-Dade County who was not allowed to bring the assister of her choice into the voting booth to help her with her ballot. I'm here to testify specifically about how language access provisions are still vitally important to achieve full equality and access to the ballot in America. An example of a recent case involving language assistance is our lawsuit brought against 32 Florida counties for failure to provide required language assistance to Puerto Rican voters with limited English proficiency in 2018, as required by Section 4E of the Voting Rights Act. Our advocacy, of course, began in the spring of 2018 when we called election officials to address their obligations to provide Spanish language assistance on materials under Section 4E, which went unanswered. Latino Justice and our partner organization, DEMOS, filed a lawsuit against the Florida Secretary of State and the 32 Florida counties, which would have forced them to provide the materials and assistance in Spanish. Because of our election protection activities, we also learned that polling places in these counties named in the lawsuit were failing to provide the materials and the assistance despite a court order requiring to do so. As a result of our litigation, the governor of Florida initiated a rulemaking process to require Spanish language ballots across the state. Yet, despite the court order and the governor's mandates, we have still been met with objections. Fortunately, the rules were passed last year, and earlier this year, we did enter into a settlement agreement with 31 of the 32 counties that now agree to provide Spanish language dominant voters materials and assistance so that they could cast their ballot. Not surprisingly, one of the supervisors of elections, Charlotte County Supervisor, declined to settle, advising that in his county, the number of voters eligible to receive these services was too small and did not justify the cost. It is also important to note that there are many instances of discrimination inside of the polls that we hear about, but because we cannot be in the polls, we cannot report on those issues of discrimination. In closing, we support the passage of voting rights laws that enforce the language minority assistance provisions currently provided by the Voting Rights Act and make those stronger. Thank you very much for the opportunity to testify today in support of these changes.
And thank you for your testimony. At this time, the chair is pleased to recognize Ms. Dillon. She will be recognized for 5 minutes. And Ms. Dillon, in reading your bio this morning, it appears that you have some connection to the adjoining county, to my home county of Wilson, North Carolina. It looks like you may have resided at one point in Johnston County, which is 2 hours south. But thank you for coming today, and thank you for your distinguished career. You're recognized for 5 minutes.
Thank you, sir. Chairman Butterfield, Ranking Subcommittee Member Steele, and members of the committee. I think we can all agree that we strongly support election integrity, including safe, fair, and free elections. I'm a Republican civil rights lawyer living in San Francisco, and I've litigated civil rights and election issues across the country for over a decade. As a young immigrant born in India, growing up in rural Smithfield, North Carolina in the 1970s, I cherish the fact that I live in the greatest country in the world and where voter participation and access is admired around the world. But declining voter confidence is a real issue in the United States today. In a post-election poll by the California Institute of Technology, 39% of respondents nationwide did not have confidence in the 2020 election results. 39%. One can accept the outcome of the 2020 election while recognizing that many voters correctly recognized several states ran roughshod over traditional voter integrity safeguards. 39% is a significant number of worried voters that should concern all Americans. This is clearly not a partisan issue. Outside Washington, where I and most Americans reside, there are practical solutions to this problem that the last 2 national bipartisan commissions on elections have endorsed. I would like to discuss 2 of those solutions today. The first is requiring voter ID. While it is not popular among elected Democrat officials and activists, it is widely popular amongst both parties' electorates. Every poll I am aware of, taken both before and after the recent election regarding voter ID, has shown overwhelming support amongst Democrat, Independent, and Republican voters. Most recently, 69% of African American and 82% of other minority voters expressed support for voter ID laws nationwide. Yet Democrats think these voters are utterly incapable of obtaining an ID to vote. As an American and an immigrant and a woman of color, I find that assumption offensive. For example, Georgia voters overwhelmingly favored requiring voter ID when voting absentee. That's 74% of Georgia voters in favor of voter ID compared to a mere 22% who opposed. One of the reasons for the overwhelming support for voter ID was put forth by the 2005 Carter-Baker Commission on Voting in a report called Building Confidence in U.S. Elections. That commission predicted our current national mood, and I quote, "Americans are losing confidence in the fairness of elections, and while we do not face a crisis today, we need to address the problem of our electoral system. That crisis is now upon us." The commission offered a simple solution, and I quote, "The electoral system cannot inspire public confidence if no safeguards exist to deter and detect fraud or to confirm the identity of voters. Photo IDs currently are needed to board a plane, to enter federal buildings, and to cash a check. Voting is equally important." Despite this bipartisan wisdom, including from our former president, Jimmy Carter, who I think no one on this panel would call a racist, Democrats are refusing to embrace the solutions of the Carter-Baker Commission, such as voter ID. Recent bills in Congress, including H.R. 1 and S1, would do the opposite of the Commission's recommendations by upending voter ID requirements across the nation. When an election administration proposal that enjoys broad bipartisan support is opposed by elected Democrats, is it any wonder why H.R. 1 and S1 have bipartisan opposition but no Republican support? Also of note, most voter ID laws today provide free IDs to those who do not have them, so that they may vote and enjoy other freedoms important in today's society, such as to buy antihistamines, to board a plane, to get a vaccination, another important issue in today's society. Such identification is necessary for practically every social service, including benefits, including welfare benefits for most in need. Why would we not want to help citizens obtain them? The argument against free voter ID is that it poses a barrier to voting. However, the evidence does not support this. A sweeping study by the Knight Foundation that sampled 1,200 voters was recently released last year, exploring why people did not vote, and the truth is painfully clear, and I quote, "Structural issues such as voter ID laws didn't come up enough to even be marked in the Knight survey results. But beyond ID, there is a second way to increase voter confidence, and that is by maintaining accurate voter lists. In DC, for instance, voters this last election cycle reported receiving 5 or more ballots intended for former residents of their apartments. This issue also has bipartisan support. In 2014, another bipartisan presidential election commission, the Obama Presidential Election Commission, had this to say: "Accurate voter lists are essential to the management of elections. The quality of the list can affect the ability of people to vote, of election offices to detect problems, and of courts and others monitoring elections to detect election fraud or irregularities. A list with many incorrect records can slow down the processing of voters at polling places, resulting in longer lines, and this has been a huge problem in recent elections. Election officials across the political spectrum recognize the value of accurate and manageable election rolls. At virtually every state election every time state election officials seek to clean up the voter rolls, Democrats sue to fight and stop such efforts." In conclusion, the unspoken truth is that all voters know that voter ID and voter list maintenance are important tools to maintain voter confidence in election administration and the results they produce. Democrat politicians and radical activists undermine that valuable confidence when they fail to support these common sense, bipartisan, and widely supported tools. Thank you for your time today, and I look forward to your questions.
And we thank you for your testimony. We will now proceed to member questions. Ms. Ledger Fernandez, looks like you're first on the list. You are recognized for 5 minutes.
Thank you so much, Chairman, and to this panel of witnesses. I think I'm going to begin with Dr. Barreto. You've conducted a number of studies and published several articles regarding language access for Latino and Hispanic voters. We also heard today about that importance for Asian American voters, and I would say, in my experience, for Native American voters, where we have several cases in New Mexico where they are required to make sure there are Navajo speakers, Kara speakers. But sticking to Spanish language voting, why is that so key for Latino and Hispano voters, the Spanish language voting materials?
Well, thank you, Congresswoman, for that question. I think you've identified that it is important for any non-English speaking citizen eligible voters, but Hispanic and Latino are the largest segment of U.S. citizen adult non-English speakers, at numbering over 5.5 million. So it is an incredibly large group of folks who are either born in the U.S., perhaps born in Puerto Rico, Spanish is the official language, and then come to the United States to vote in elections here. Those voting materials need to be available in the language that the voter is comfortable with so that they can properly understand all the rules, the procedures, as well as who the candidates are and how to mark their ballot. Numerous political science studies have documented about a 10-point increase in voter participation for Spanish speakers if they have access to bilingual voting materials. So there's no question that empirically it has proven to help boost voter turnout rates of those who are otherwise eligible, but perhaps are not fluent in reading and speaking English.
And your testimony and answer to this question, as well as others, really brings us back to the fact that there is also an impact on returning voters, right? That if you are harassed, if you are treated in a way that is different than others when you go to vote the first time, that you might not come back. And so that there is a very dangerous possibility of future suppression. So the Voting Rights Act language access provisions, what kind of impact have they had on Latino and Spanish language voting?
Well, where they have been implemented fairly and fully, which is important to note that it is not always implemented fully. There needs to be better oversight of implementation of language access provisions, both Section 203 and Section 208. But where they have been implemented fully, we have seen a higher voter participation rate, both first-time voters, as well as you note, of returning voters. One of the most difficult things can be for a voter which has language challenges to navigate the system. And if they don't feel that they can do that, if they don't feel welcomed, if the language materials are not available, as you note, they may just leave and not come back. They may feel excluded from the system. Where Section 203 is implemented, there have been very robust increases in Spanish-speaking Latino voter participation.
Thank you. And based on your research, what do you think are the reasons that Americans, as has been one of the witnesses stated today, might not have faith in our elections?
Well, faith in our elections is very important, and I would agree with that sentiment. But it is important that those voters who show up to vote don't feel that they're being discriminated against for any reason, whether it is for language, for lack of ID, or being challenged at the polls. When those sorts of instances happen, where voters have a negative experience at the polls and are challenged or not able to navigate the polling place, that leads to a rejection and withdrawal. And so that is an important part of confidence, is having a accessible and confident experience at the polls.
Right, and the numbers are vast in terms of what one court has called an infinitesimally small number of evidence of fraud versus the very high percentage of Latino and other language speakers who are turned away. Ms. Romero-Craft, so existing law, as Dr. Barreto just pointed out, it requires that there be Spanish-speaking assistance. What do you believe are the principal reasons that states and localities do not comply with the statutory obligation?
I think there are a number of reasons, but I think one of the ones that is really a barrier for Spanish language dominant or other voters who speak another language other than English is that when they even go to ask, they're turned away. And just as you as rightfully stated, if they're turned away and they don't know where to go, they don't know who to ask to receive assistance, then we may never hear of their complaint. We may never hear of their experience. And I think, you know, sometimes these issues are couched by elections officials as being cost prohibitive. But what we have found in jurisdictions all over the country is that there are practical ways that election officials administer their votes and are able to meet those challenges of providing language assistance to voters in very ways that are extremely reasonable. For example, in the state of Florida, the secretary is required to provide information in Spanish across the entire state. So the election officials rely on those organizations in order to do their job.
Thank you, Mr. Romero. Mr. Chair, I'd like to enter two documents into the record. As I seek unanimous consent to enter translating into votes the electoral impacts of Spanish language ballots and voting rights for whom, examining the effects of the Voting Rights Act on Latino political incorporation.
Certainly, without objection, both documents will be received.
Thank you. I yield back.
Young lady yields back. At this time, the chair will recognize the ranking member, Mr. Style, for 5 minutes.
Thank you very much, Mr. Chairman. I would seek unanimous consent to enter into the record 3 polls, the Marquette University Law School poll, the YouGov Economist poll, and a Gallup poll that shows support for voter ID.
Without objection, each of these polls will be received into the record.
Thank you very much. Question for Ms. Harmet Dillon, if I can. Aside from federal law, could you share why you think it's important for states and local governments to keep voter registration lists up to date?
Well, I think voter confidence is a significant problem that the Carter Baker Commission recognized as far back as 2005. And I think we've seen the results of that. For example, you saw a drop off in participation between the Georgia 2020 November election and the runoff election. And certainly anecdotal evidence supports that voters expressed decreased confidence in the integrity of the election as a reason for not voting. And so while it is true that documented instances of fraud are low, the bigger problem is that I think everybody here on this committee and speakers here would agree that we want every American to vote and feel confident in voting, and voter rolls being cleaned and maintained regularly is an important part of that. And dating back to that 2005 commission, there were recommendations regarding the sharing of data amongst the states. Certainly states are under a mandate to keep their voter rolls updated, but in my beautiful state of California, as recently as 3 or 4 years ago, litigation was required in Los Angeles County that demonstrated by Judicial Watch that over 1 million people were registered on the ballots of one county in the United States alone who did not have an entitlement to be on that. That is duplicates, that is people who have moved, people who have died, people who are otherwise ineligible to vote. Other states have similarly showed similar problems. Pennsylvania has had problems with immigrants, legal immigrants, being registered inaccurately on the voter rolls, which can have devastating consequences for new immigrants who may not be aware that voting before you are a citizen is a crime. That is a tragic outcome of government incompetence. So these are some of the reasons why it's important to have clean and accurate voter rolls.
It's actually, I think you actually bring up a really good point, in particular the impact that some of these automatic voter registration requirements, in particular that is drafted in the HR 1 that passed the House, I think could have a really detrimental impact on some of our communities who are here, who are not citizens of the United States, who would find themselves on voter lists. If any of them accidentally voted, there'd be significant consequences for them as a result of the state putting them on automatic voter registration. We've seen that play out in Illinois. Could you speak a little further in particular about how some states that really haven't been maintaining their list, the impact that that's having on voter confidence? Have you studied the impact that voter confidence has on improving turnout? I mean, I think you and I agree on this. We want to make sure that everyone is able to exercise their constitutional right to be able to vote. We want to make it easy to vote, hard to cheat. And in one aspect of this, improving voter confidence in the election system, I would think would enhance and encourage further people to go and exercise their constitutional right to vote. Have you studied and analyzed the impact that has, or could you add a little color to that?
Well, I'm just a country lawyer, as they would say. I do not perform studies like many of the learned scholars here on this panel and speakers. However, I am a trial lawyer and I introduce evidence. And the evidence I've seen in this matter has shown me that the problems regarding voter confidence and the declining nature of the voter confidence in some circumstances is very real. I think it was a different night study that showed that people are confident in their own vote, and I would put myself in that category being accurate. But as you ask them about the confidence in the county level and the state level and the national level, that confidence decreases significantly. And so I think a principle of uniformity is important, and that's one thing that we did not see in the recent election. We saw certain counties, for example, in certain states where significant money was provided by nonprofits, by Mark Zuckerberg's nonprofit, where the signature matching in some counties was radically different than the signature matching settings in other counties, depending on who was paying for that election monitoring.
Yep.
That decreases confidence in voters of uniformity and equality. And so I think that is a very important principle that we need to have.
Thank you very much. We saw the impact firsthand in Wisconsin of the funding that ultimately Mark Zuckerberg put in on making sure the impact that it had on municipalities maybe not operating in a similar manner across our state. I appreciate your testimony today, and Mr. Chairman, I yield back.
Gentleman yields back. Thank you. At this time, the chair recognizes Mr. Aguilar for 5 minutes.
Thank you so much, Mr. Chairman. I was a little confused about the entrance of polling data into the official record. But if that's the precedent that we're going to have, that's fine. Very popular ideas like universal background checks, protecting a woman's right to choose, and passing comprehensive immigration reform also poll very, very popular. Mr. Romero-Croft, you have successfully brought legal actions to compel states and localities to comply with the Voting Rights Act's language access provision specifically. Do you think this litigation is a sufficient tool to ensure that states and local governments provide multilingual voting support? And if not, why isn't it?
It is a tool, and it's a tool that should be available to all Americans if they feel that they were not able to exercise their full voting rights. However, I will say it is a deficient tool because frequently it's after the fact. And so it's a protracted process. Our litigation that we filed in 2018 took 2 years. And by that time, a lot of harm can happen to communities that are looking to exercise their rights to vote. So I would say oversight by the government, oversight is absolutely necessary. We also understand that, for example, in Pinellas County, where they had to comply with Section 203 of the Voting Rights Act to provide Spanish language dominant voters their access to materials and assistance, they had an election when they were designated after the census that happened 2 months after their designation. And DOJ oversight made it so that they were complying with Section 203. So I think it's critically important that we pass laws to strengthen the Voting Rights Act and to make sure that minority language voters are able to exercise their full rights as provided by federal law.
When you've challenged state and local governments for their failure to comply with their obligation, how long does it take for your clients to obtain that relief?
It can be, it depends if you're going in on emergency litigation. Sometimes you can have sort of have a court intervene very quickly. Other times, if you wait too late, you can have the courts toss out the case. I mean, there are all these different examples, but in the example that I have shared with everyone today, it took 2 years, and it is a settlement agreement. But I think what folks really have to remember is that this is a process. It's not something that happens overnight. Outreach has to happen to communities that are impacted. Outreach has to happen to the voters. There has to be a certain amount of education to election officials, and poll workers change. So that has to be a constant process that is updated. And in a state like Florida, where you have elections year round, and election laws change frequently. You have to be vigilant, and you have to make sure that you're reaching the impacted voters. I think that's probably one of the most important things that we can, take away from these changes.
Thanks, Ms. Romero-Croft. Ms. Minnis, unlike the Latino voting population, which primarily includes voters that speak English and Spanish, the AAPI community consists of voters that speak a variety of different languages. Why is access to multilingual voting information and support particularly important for Asian American voters?
Thank you very much. I think that one of the reasons harkens back to what I discussed about the history of discrimination, particularly with respect to the immigration laws, and how that means that our population is much more highly immigrant, are more likely to come from other countries, from other voting systems, other democratic or perhaps not so democratic systems. And so that is a lot of new information that needs to be assessed and synthesized in order to be able to vote. We know that the voting process can be very complex, even for folks born in this country and speak only English. And so in language materials, not just the ballots, not just the bilingual, poll workers at the polling site, but really the purpose of Section 203 in making all voting materials accessible in the covered language, whether that's registration forms or, sample ballots and the like, is so critical, particularly for a community like Asian Americans that have such high levels of English, languages other than English being spoken at home, high levels of limited English proficiency, and high levels of being born outside of the country.
Well, and we know in recent years, Asian Americans have been among the fastest growing blocks of voters in the United States. So this is something that obviously needs to, we need to pay attention to, and we need to ensure that it keeps up with that our changes keep up with the rapid growth of Asian American voting population. Thank you so much, Mr. Chair, and I'll yield back.
Gentleman yields back. At this time, the chair recognizes Mr. Davis. Is that right? Mr. Davis for 5 minutes.
Thank you, Mr. Chair. Appreciate again the witnesses being here. Harmeet, it's great to see you again, and thanks for being a part of this panel.
Thank you, thank you, Ranking Member.
Hey, you're a constitutional attorney, right, Harmeet?
That is correct.
Part of our Constitution, specifically relays that our elections should be run at the state and local level. Another very important part of our Constitution is the right of every American to be able to petition their government, right?
That is correct. First part of the First Amendment.
So it's part of the First Amendment, and here we are today. We're having another hearing about voter ID, and at the same time, Speaker Pelosi is requiring anyone who visits the United States Capitol to come petition their government to show an ID. So is Speaker Pelosi racist?
Well, I won't. She's my representative, and so I won't go so far as to say that. However, I would say that it is very unfortunate that Speaker Pelosi has limited the right of petition. In fact, I have a lawsuit pending against Speaker Pelosi and the United States Congress concerning the right of people to be able to pray on the Capitol grounds. So certainly some constitutional rights are more equal than others today. But I think that right of access to the polls is incredibly important as an immigrant. My mother was a poll worker in Johnston County, North Carolina, a poll observer rather. And, in the 1970s, the access to voting for minorities in this country in the South was very different than it is today. And I think we need to recognize the great strides we've made in this country and make laws that are relevant today, not laws that hearken to eras, decades gone by.
I certainly couldn't agree more, Ms. Dillon. As my good friend, Mr. Aguilar mentioned, there was some polling data that was discussed by Ranking Member Stile. I see even higher numbers in those polls than I see in polls related to the issues that my good friend, Mr. Aguilar brought up. But why do you think many of today's panelists are opposing the will of this large majority of voters who support pragmatic voter ID laws?
Well, I wouldn't want to speculate, and certainly I think some of the speakers here have cited studies, but self-reported studies of survey participants is very similar to a poll, in my opinion, and so you can take those or leave those. We simply don't have accurate data, even around the world, if you look at studies around the world, of why people don't vote. There are many different theories. Certainly one of them is this confidence issue, and it's been discussed in a bipartisan basis for many years. I think it is incumbent upon elected officials to increase voter confidence and try to get that participation up. The participation is higher in some developed countries around the world than it is in the United States. And so if barriers include the cost of ID, and I accept that as true, the government should work to eliminate those barriers as opposed to eliminating the safeguard. That seems to be very common sense. And where you see government officials pushing required vaccination to enjoy basic civil rights, another issue that I'm litigating, you question why they don't want to solve that problem of identification that is required to access so many fundamental rights today.
You mentioned some very good points there. And as we look ahead, I too agree that if there's going to be voter ID requirement, why not offer them for free? Throughout the entire last Congress before the pandemic hit, we were traveling the country, going place to place, talking about some of these issues. And each and every time a voter ID was required, there was a way to identify somebody at the lowest at the lowest cost, and in the most convenient way possible. Now you bring up another interesting aspect. It's the COVID-19 vaccine. We saw election authorities put in emergency procedures in the 2020 election cycle throughout this country, your home state of California, my home state of Illinois. And at the same time, now it seems many of our colleagues would be okay requiring a COVID vaccination to go into a polling place, but not a voter ID. Wouldn't that be a form of an ID?
Well, of course, and it's very intrusive and violates numerous civil rights. That's not what I was called here to testify about today, but if that becomes a requirement, there will be litigation certainly over that maybe even bipartisan litigation over that.
I knew you weren't here to testify, but I thought it was an interesting question. I know you can react to the questions well. I know you all. I've met you and I've seen you in action before. One real quick question. California, your home state, please give me an idea of what happened with the voter rolls and also how it seemed that many voters received multiple ballots in the last election.
This is a problem throughout the United States that is compounded by the lack of clean voter rolls in our country. And there have been current Senator to United States Senator Alex Padilla was responsible for that election administration, and many people who are not citizens through no fault of their own have been automatically registered to vote. People have experienced multiple registrations. The fact that the state settled a case involving over 1 million registrations in Los Angeles County should have led to the cleanup of those voter rolls and cleanups throughout the state of 58 counties. That has not happened, and more litigation is likely imminent because a lack of integrity and consistency among our voter rolls does decrease voter participation and voter confidence.
Thank you, Mr. Chairman. My apologies, I did go over, but I appreciate your consideration allowing me to continue. I yield back.
The gentleman yields back. I saw you winking your eye, Rodney, so I knew you were winding down. So we can be flexible sometimes, especially with the ranking member. Thank you very much. At this time, the chair recognizes Ms. Scanlon for 5 minutes.
Thank you, Chairman. Mr. Barreto, your testimony indicates that proponents of voter ID laws seek to justify them on the grounds that election fraud by ineligible voters is rampant. Could you comment on whether research, evidence, or if you know judicial decisions support the claim that widespread voter fraud by ineligible voters has the possibility or probability of impacting election results?
Thank you for that question, Congresswoman. There has been no such study to document voter fraud in elections by persons attempting to pass them off as someone else, something that voter ID would supposedly catch, impacting election results. The most recent one that comes to mind for me is the case in North Carolina of someone taking ballots and remarking them. This is not something that voter identification laws would have blocked, and there is no research study or government commission which has looked into this extensively. There's no study that finds this theoretical, hypothetical myth of voter fraud is actually happening in our elections. And so it has been thoroughly debunked by social scientists and has not impacted election results.
Thank you. And certainly there were no court cases in the most recent round that were able to establish any such thing. I would also submit that the corrosive impact of these unjustified claims has actually increased attempts by individuals to commit voter fraud. We've certainly seen that in Pennsylvania, where numerous supporters of the former president were arrested in the most recent election and charged with voter fraud because, having been told it was so easy to do, they attempted to vote for dead relatives or vote multiple times, and in fact, they were caught and charged. Ms. Romero-Kraft, in Pennsylvania, we have a substantial population of Puerto Rican-born residents, and I discussed the problems with strict voter ID laws with the previous panel. I mentioned that I'd participated in efforts to help low-income residents obtain ID so they could vote. One of the issues that we encountered was that in 2010, Puerto Rico had invalidated all birth certificates issued before that date in order to increase the security of those documents. And that really increased the degree of difficulty for anyone born before 2010 in Puerto Rico to get the voter ID that they needed. Can you comment on the impact of that law and what you've seen around the country as American citizens born in Puerto Rico try to register in other states?
Absolutely. I thank you for bringing that up, because that is one of the things that folks don't recognize, is that U.S. citizens of all walks of life can have difficulties in obtaining their birth certificates. In Puerto Rico in particular, sometimes folks have to travel to the island, which can be a prohibitive cost for folks to obtain their updated birth certificate. You know, I can speak to, my sister was born in New York City, and she had a misspelling in her name and had to go and get her birth certificate. She called me complaining, and I said, you know, as someone who practices under immigration law, I said, you know, get in line. These are problems that people have, and a lot of these challenges, you know, are borne by folks who don't have the resources to do what they need to do in order to get their updated materials. And I would say for Puerto Rican U.S. citizens in particular, what we see are, you know, take the case of Puerto Rican citizens in Georgia, and it's happened across the country, where they were being discriminated against. We had our lead plaintiff in our litigation. He was arrested, charged with 2 counts of felony fraud for presenting his Puerto Rican identity documents when all he was trying to do was simply get a driver's license. And you can imagine that our investigation found that folks as early as the 90s had been undergoing the same kind of discriminatory treatment in the state of Georgia, and were not able to obtain identity cards or a driver's license. Their documents were confiscated, if you can imagine, and it was happening. And so you found communities that were terrified, that did not want to go and get identity cards. And these issues, they raise serious concerns on behalf of community members. But not only that, they impact things like voting in a very significant way. It takes a lot of time to bring the community back, to make them feel that sense of belonging, but also that sense of trust. And those are the issues that we confront day in and day out in our work.
Yeah, we certainly saw the same thing in Pennsylvania with trying to get them. And in fact, my law firm sent a paralegal to Puerto Rico to try to obtain birth certificates for numerous clients who we were attempting to assist. So thank you for that testimony. Chairman Butterfield, I would yield back.
Gentlelady yields back. All right, it looks like I may be next. The chair will recognize himself for, I suppose, 5 minutes or less. Ms. Romero-Kraft, you mentioned that even after you obtained the settlement in the Florida language access litigation, you still had difficulty with the subject jurisdictions complying with their obligation to provide Spanish language materials. Could you further explain why litigation is not sufficient, it's insufficient, to ensure that states and local governments comply with their obligations to provide multilingual voting materials?
I think one of the ways, the most significant ways that it is insufficient is because, unfortunately, you know, we don't have the resources, despite the fact of being part of a large election protection coalition, to monitor all of the places where these issues have impact on voters. And so oversight is necessary. You know, I have to say that, you know, folks are not afraid of us in some cases. They either don't think we'll file litigation, or they think that voters aren't impacted by this. And so one of the ways that I think would be very impactful for our voting rights laws to be updated is to make sure that they enforce the provisions that allow for federal oversight when settlement agreements like ours are entered into, to make sure that the election officials know that they have the full force of the government then coming in to review the changes that are necessary to be made to comply with this. And again, the harm can be done if these election officials don't comply, like we saw in our case that we filed in 2018, where we had a supervisor of elections who refused to provide these materials, that they then go ahead and they comply with what the law requires or what a court order requires. So just litigation simply is not enough. It has to be a multi-faceted approach that we take to make sure that our voting rights.
Let me move over now to Dr. Burrito. Dr. Burrito, you have conducted extensive research into the burden posed by voter ID laws on minority voters. The Republican witness, Ms. Roman, on the last panel, emphasized during her testimony that several studies have not found a significant decline in turnout associated with voter ID laws. Help me with this. Please explain why voter ID laws impose a discriminatory burden on minority voters, even assuming those studies are correct, that any adverse effect on turnout is not substantial.
Well, I think first of all, the literature is quite clear on turnout, as Dr. Lajavarde told us earlier. There is a decrease in actual turnout in areas with strict voter ID. But I think it's important to remember that those turnout studies are often the turnout of Americans with ID. And this is in reference to the discussion of the polling points as well. About 85% of eligible voters do have an ID. So when increase in an election goes up, about 85% of Americans are able to still vote under strict ID cases. But we need to be looking at those 15%. This is our job, to protect the rights of those 15% who do not have an ID. And in the case of strict voter identification laws, they're not even eligible to participate in the first place. So while other people might vote at higher rates who do have a driver's license, there is no question that validated studies which match the voter rolls to the DMV databases show that for existing registrants and existing voters, when voter ID laws go into effect, they greatly limit Black, Latino, and other immigrant community voter participation.
Thank you. This is my final question, and it goes to Ms. Menace. Ms. Menace, what changes to the federal law governing access to multilingual voting support are particularly important to protect the interests of Asian American voters?
Thank you very much for that, Chairman. I think it is very important that anytime we are looking at legislation that would improve access to the ballot for eligible Americans, that we are looking at ways to increase language access. So, for example, you could have legislation that includes incentives to hire bilingual poll workers. You can also include provisions that would, require cultural competency training as well as linguistic, access training for poll workers. That is certainly something that we have seen throughout the years to be problematic, where sometimes it can be a hostile poll worker, and sometimes it could be simply a poll worker who's not particularly aware about the best way to engage with an LEP voter and or how to properly provide language access and assistance. So I think that looking at the provision of voting rights, the provision of ballots, and just the entire voting process, seeing that as a community service model, as one to address the needs of the voters themselves, I think that is a way that different pieces of legislation can help improve that. And of course, continued enforcement of the Voting Rights Act, Section 203 and 208, as have been previously mentioned by other panelists, also remain very critical. And to the idea of, making sure that we have proper engagement and active Department of Justice helping to defend and enforce those rights, in addition to groups on the ground, I think are ways that we can make sure that the language rights and the voting rights of our Asian Americans, of other eligible Americans are best protected.
Thank you very much for your testimony. This will conclude the portion of this hearing dealing with member questions. I not only thank the witnesses, but thank my colleagues for your patience. It's been a 2.5-hour hearing and you have hung in there, and just thank you very much. It's 1:30 p.m. on the East Coast, and so I think we need to go ahead and complete the hearing, and just thank you to the witnesses. Thank each one of you for your valuable testimony, and the members, your questions on both sides of the aisles have been very, very enlightening and helped complete this record. The members of the subcommittee may have additional questions for the witnesses, and if so, we will ask you to respond to those questions in writing. That is, to ask the witnesses to respond to those questions in writing. The hearing record will be open for those responses, and it will be held open for a period of time. Thank you again to all of our witnesses for your testimony today. Is there any other business to come before the subcommittee before we adjourn? Hearing none, I'm going to get an opportunity to use my gavel, which I have not used today. I will say the hearing is adjourned.